Good evening, everyone. Thank you for giving me an opportunity to address all of you on the topic of Babri Masjid, a victim of injustice. When we first came across the judgment of the Supreme Court in the Babri Masjid and Ram Janmabhoomi case, we were disheartened. The first reaction of the VCK, which we made clear through our press release, was to demand a review petition to be filed against the judgment and to wait patiently until there is justice. This judgment of the Supreme Court came after a 10-year legal battle challenging the Allahabad High Court judgment on the question of ownership of the contested land. The 5-judge bench Supreme Court judgment delivered in November 2019 does not mention the name of the judge who authored this verdict. This is unprecedented in the history of Indian judiciary. If the judge who authored the Babri Masjid verdict felt that this was a great judgment, he would have certainly laid claim to him authorship and used his name. We are led to doubt that even the judge who authored this judgment does not believe in it. We appreciate two aspects of the judgment. First, the confirmation in this judgment that secularism is the bedrock of the Indian Constitution. Second, that both the placement of the Ram idol in the Babri Masjid in 1949 and the demolition of the masjid in 1992 are illegal acts. The judgment clearly states that there is no evidence that a Hindu temple was demolished to pave the way for the building of Babri Masjid. This is implicitly makes it clear that Muslims have not done any act of illegality in this case. At the same time, this judgment makes it clear that placing the idol of Ram within the masjid and the demolition of the Babri Masjid are both illegal acts. However, in spite of such observations, the Supreme Court has given the land in the hands of the same people who acted illegally. This makes everyone confused as to whether such an approach of the Supreme Court falls within the purview of law. The Allahabad High Court in its 2010 judgment, in this case, divided the contested 2.77 acres of land into 3 and awarded 1 portion to the Muslims and 2 portions to the Hindus because people felt that this itself was unjust. A review petition was filed in the Supreme Court in the belief that there will be justice there. However, here the Supreme Court has ruled that even that 1/3 portion will not go to the Muslims. The Supreme Court had appointed a mediation panel in this regard, which in turn submitted its recommendations to the court within a sealed cover. It is only after receipt of this sealed cover did the Supreme Court commence the final hearing on this matter. When we read this judgment, we get the feeling that this judgment would have been authored on the basis of the recommendations made available in the sealed cover. More than being a judgment made on the basis of law, this appears to be a judgment made with the protective sentiment that law and order should not be destroyed. When all other state apparatus have been dismantled and destroyed beyond recognition, people looked up to the Supreme Court of India as their only savior. We are unable to say that their hope has been resorted by such a judgment. Here, I wish to state that in the ideological battle between democracy and Sanathan forces, the VCK will always stand on the side of democracy. Everyone is under the assumption that we are on the side of Muslims. No, that is misleading. We are standing on the side of democracy, on the side of justice. When the first protests took place against the judgment in Chennai, I reminded everyone that we were rallying not against the Supreme Court judgment, but rather against the fascism behind the Supreme Court judgment. We are not against Ram. We are against the fascist forces who misuse Ram's name. We do not oppose a temple for Ram or a temple for Hanuman. It is just that at the site where the 400-year-old Babri masjid was demolished, the right demand is for the Babri masjid to be rebuilt at the same spot. In the 1045-page judgment of the Supreme Court delivered by a 5-judge bench, which included the Chief Justice of India, over 160 pages involve references from Puranas simply to emphasize that Rama was born in that place. There is no other evidence in favor of Rama's birth in this judgment. Rule of law means the judgment can be returned only on the basis of the evidence. The Supreme Court, the last fortress that is meant to protect Indian democracy, heard the Babri Masjid case. The Hindutva argument has always been that the Babri Masjid was the place of birth of Ram and that the mosque was demolished only because of it was on Ram's birthplace. However, the Supreme Court itself searches for evidence of Ram's birthplace only using the Puranas. Likewise, on the question of pre-existing structure under the Babri Masjid, the Supreme Court has held that the pre-existing structure was not a temple and also that it was not a mosque based on the observation of ASI. The question which requires jurisdiction was whether there existed a temple and whether that temple was demolished to build a mosque. Any other questions are superfluous. As per the ASI report, which the Supreme Court accepts, there was no temple at the site where the Babri Masjid stood. If there was no temple, it means there was no Ram temple. No Ram temple was demolished in the construction of the Babri Masjid. That gives rise to the pertinent question: why was the Babri Masjid demolished? The same Supreme Court which held that placement of the Ram idol in 1949 was illegal and that the demolition of the Babri Masjid in 1992 were illegal, has given the 2.77 acres of land to the very side which carried out the demolition. We do not want to criticize the judgment of the Supreme Court. We merely want to place on record that it was injustice. This is a judgment which has not relied on documents or witness, but on the Shastras. It appears that all the 5 judges were led by a single fear. If Muslims are deprived of that land, there will be peace in India. If Hindus are deprived of that land, there will be unrest in the nation. That is why Modi said, there is no need to celebrate this as a victory or as a defeat. If Hindutva forces had lost the legal battle, would this have been Modi's statement? There has been no national level debate on the issue of this judgment. Media in India so heavily curtailed, so deeply gagged that they cannot even hold an open debate about this judgment. This threat to the media is what constitutes fascism. Today I speak here because I am opposed to Sanatana fascism. Fascism might be an Italian word that applies to Mussolini, but in India, fascism has another name, Sanatana. It is this Sanatana that denies justice to the minorities, which upholds the fourfold Varna system, which discriminates people on the basis of birth. VCK's history of opposing Hindutva forces is not new. Even in 1990s, as an emerging movement in Madurai, we ran a campaign against Advani's Rath Yatra. Our party, our movement has always led the struggle against religious majoritarianism and sectarianism. Thank you for giving this opportunity.